Welcome to my YouTube channel. Please like, comment, and subscribe. Houston crew members injury claims. Getting injured as a crew member on a ship in or around Houston can happen in an instant. Fortunately, there is a way for maritime workers to recover compensation in offshore injury cases. In almost every case, filing a crew member's injury claim is complicated, stressful, and potentially risky if you make careless errors. That is why so many injured maritime workers seek out an attorney to help with their claims. And then next about crew member injury claims under the Jonas Acts. Maritime accidents that occur away from shore, harbor, ports, docks, and the like are typically covered under the Jonas Acts. Unlike the Longshore and Harbor Workers' Compensation Acts, which provides compensation regardless of faults, the Jonas Act requires injured crew members to file a lawsuit against their employer for negligence to recover compensations. This federal law enables injured seamen to sue for full compensation for their damage from a crew member injury, but it also requires all of the steps to filing a lawsuit. You will need to collect evidence on your employer's negligence, demonstrate how that negligence caused your accident and subsequent damage, and potentially argue in court or during settlement negotiations. And then next, who is eligible to file a claims? Not everyone who works in the maritime industry is eligible to file a crew member injury claim. The following are the requirements for crew members to file a claim under the Jonas Act. You must be a sailor or seaman. You must spend at least 30% of your time on the vessel in navigable waters. If you meet the above requirement and your employer's negligence caused your injury, you can file a claim under the Jonas Act. Keep in mind that this is true even if the vessel was docked when the accident occurred. And then next, employer negligence in crew member injury claims. To recover compensation through a Houston crew member injury claim, you will need to demonstrate that your employer negligence led to your accident and injuries. Negligence at sea can take many forms, but the following are some common types of employer negligence that lead to Jonas Act claims. Filings to train crew member properly. Failing to provide proper equipment for the job at hand. Failing to maintain an environment free of slip and health hazards such as oil on the decks. Failing to uphold workplace safety requirements. Failing to maintain equipment. You will likely have to demonstrate that the vessel on which you were injured was unseaworthy. In maritime law, this term applies if any aspect of the vessel was improperly maintained or present in a way that caused your accident. It does not mean that the vessel literally cannot be navigated. And the next compensation you could recover. Filing a Jonas X claim as an injured crew member should enable you to pursue compensation for every harm or loss you have suffered. Common losses in Houston crew member injury claims include medical costs, lost income during recovery, disability, pain and suffering, and emotional trauma. Separately from the Jonas X, seamen are entitled to maintenance and cure after an on-the-job injury. Maintenance refers to daily living and housing costs. Cure refers to medical costs. These benefits are supposed to start the day of your injury, but many employers will try to delay them or give an amount that is not enough to cover your damages. And then pursuing maximum compensations. A Houston Maritime and Offshore injury lawyers. Maritime and offshore workers have been a vital part of the American economy since colonial times. Despite advancement in safety technologies and government regulation, maritime and offshore workers have an extremely high risk of suffering an on-the-job injury. When they mean that while length-based regulation for personal injury lawsuits mostly apply in the Jonas X and admittedly claims, a maritime injury trial can look quite different than a land-based personal injury claims. Namely, maritime lawsuits are likely to call for some other form of compensation. Here are a few common forms of maritime compensation. Maintenance and cure. These are other maritime rights that all injured seamen are entitled to from the moment they are hurt. Maintenance refers to your daily housing and living costs. Cure refers to your medical bills until you reach maximum medical recovery. Income replacement. You can sue for this damage under the Jonas X, but you are also entitled to it under the LHWCA. Specifically, you are owed two-thirds of your income if you are injured and qualify as a harbor, port, or dock worker. Thank you for watching this video. Don't forget to give like, comment, and subscribe.